Right. Settle down, everyone. Welcome to today's masterclass. We're going to dive straight in. Today, we're undertaking a highly focused explainer of a pivotal topic in property law. I'm going to provide you with the exact, step-by-step architecture you need to draft a maximum scoring 16-mark exam answer on fraudulent transfers. We're dealing with rigorous academic standards here at KSLU, so I need your absolute focus. Let's properly structure our knowledge for the examiner. On the board, we have our synopsis. 1. Introduction and meaning. 2. Essential elements of transfer. 3. Grounds to set aside. 4. Exceptions and protections. 5. Illustrations of fraudulent transfers. And 6. Landmark case laws. You must begin every KSLU answer script with a clear roadmap exactly like this to demonstrate structural clarity to the evaluator. Let's move straight to the first heading. Heading number 1. 1. Introduction and meaning. When you write this on your exam booklet, I remind you to strictly underline your main headings. You must signal to the evaluator exactly where your analysis begins. Read what's on the board. The law protects creditors from dishonest transfers made to defeat their rights, dealt with under Section 53 of the Transfer of Property Act 1882. Now, why do we start like this? Because citing the specific statute and instantly hitting the examiner with Section 53 immediately establishes your competence. It proves you aren't just waffling, right? You know the exact statutory provision governing the protection of creditors against dishonest debtors. Moving to the statutory meaning. A fraudulent transfer is a transfer of property made with intent to defeat or delay the creditors of the transferor. Now, pause and look at me. The phrase intent to defeat or delay must be memorized word for word. When you write this definition, you will take your pen and you will underline intent to defeat or delay. That intent is literally the heartbeat of Section 53. If you miss those words, well, your definition is legally incomplete. Moving to our next crucial heading, 2. Essential elements of transfer. When drafting this section on your answer sheets, I am explicitly directing you to use distinct, numbered bullet points. Don't just clump this into a single paragraph. Let the elements breathe on the page. Here they are. 1. Transfer of property must take place. 2. There must be creditors. 3. Intent to defeat or delay creditors. 4. Transfer may be real or ostensible. I am elaborately warning the classroom right now. Omitting even one of these 4 elements is going to result in a heavy loss of marks. The examiner is looking for this exact checklist in your answer. First, an actual transfer. Second, the existence of creditors who are owed money. Third, that malicious intent we just discussed. And fourth, it's absolutely crucial to understand that the transfer doesn't even have to be completely genuine. It can be an ostensible or, a make-believe transfer just to hide the asset. Now we enter heading 3, grounds to set aside. This is the core analytical body of your essay. This is where the evaluator will look for deep understanding. They want to know, under what factual circumstances can creditors actually step into a court of law and challenge a property transfer? Note these 5 circumstances. 1. Intent to defraud, the primary condition. 2. Without consideration, referring to gratuitous transfers. 3. To close relatives. 4. When debts are due. 5. Covers entire property. Now, in a long-form answer, you don't merely list these, you elaborate on them as circumstantial evidence of fraud. Think about it. How does a creditor prove what's inside a debtor's mind? They show the court these circumstances. They point out, look, the debtor gave the property away for free without consideration. They highlight that it was suspiciously transferred to a close relative just when the debts became due, leaving absolutely no other property behind to pay off the loans. It's like a giant puzzle, and this brilliantly illustrates how circumstantial evidence builds a solid case for fraud. Look at the nature of remedy on the board. Such transfers are voidable at the option of creditors. Transfer is not void, but voidable. Creditors may file suit to set aside. Let me sternly drill this fundamental legal distinction into your minds right now. Void versus voidable. A void transfer is dead on arrival. It has no legal effect from day one. But under Section 53, the transfer is strictly voidable. This means it is entirely valid until the defrauded creditor actively chooses to go to court and file a suit to set it aside. Precision in your terminology here is non-negotiable. If you write void instead of voidable on your KSLU exam, you're telling the examiner you fundamentally misunderstand the remedy. We now shift at heading 4, exceptions and protections. A top-tier law student never just argues one side, right? To secure maximum marks, you've got to present a balanced argument by showing the statutory exceptions. The law protects creditors, yes, but it also protects innocent buyers. Read the exceptions. 1. Bonafide transferee for value. If transferee paid consideration and acted in good faith, the transfer is valid. 2. transfer made for legitimate purpose, not intended to defraud creditors. Let's break down this dual requirement. For a transaction to be protected, the buyer must have paid value, meaning real consideration, not just a token amount, and they must have acted in good faith, meaning they had absolutely no knowledge of the seller's secret intent to defraud their creditors. Only when both elements exist together is the genuine transaction successfully protected from being set aside. Heading 5. Illustrations of fraudulent transfers. I cannot stress this enough. Providing clear, practical illustrations is the fastest, most effective way to prove your conceptual clarity to the KSLU examiner. It shows you understand how the Bear Act applies to the real world. Look at this comparison. On the left side, A transfers property to brother to avoid paying debts. Creditors can challenge, transfer voidable. On the right side, A sells property to B for fair price in good faith. Valid transfer cannot be set aside. I explicitly instruct you to draw a similar comparative visual, perhaps a small table, right there on your exam paper. Contrasting a voidable transfer against a valid transfer side by side demonstrates an examiner-friendly structure that practically guarantees marks. We have arrived at heading 6, Landmark Case Laws. I demand absolute silence and focus as we cover the jurisprudence. This is the most critical section for securing a perfect score. You simply cannot write a 16-mark property law answer without citing authoritative case laws. Abdul Shakur v. R.G. Paparao, transfer intended to defeat creditors held voidable. I am emphatically ordering you to write this exact citation in a separate, neatly drawn box on your exam paper to capture the evaluator's eye. Let us explicitly detail the background of this ruling based on the principles of Section 53. The underlying factual scenario involves a debtor actively transferring their assets with the specific, dishonest intent to keep those assets out of the hands of their legitimate creditors. The final ratio decidendi, or the verdict of the court, established firmly that such a transfer cannot stand if challenged. It is declared voidable at the option of the creditor. The absolute relevance of this case is that it cements the primary condition of intent we discussed earlier. It tells us that Indian courts will actively look through the facade of a transfer if the core intent was to defeat debt recovery. Make sure you underline this case name in your KSLU script. Krishna Kumar Berla vs. Rajan Singh Lodha emphasized importance of bona fide transactions. Again, place this in a boxed format. The background here conceptually anchors the defense under Section 53. While creditors need protection, commerce would literally grind to a halt if every property sale was overturned. The court's verdict here heavily emphasized the protection of the innocent party. The ratio dictates that if a purchaser enters a transaction honestly, paying fair value without any knowledge of the seller's underlying financial mischief, their rights to the property are paramount and absolute. The relevance of this case is that it acts as a perfect shield against the sword of Section 53. Pairing this specific bona fide defense case against the Abdul Shakur case demonstrates total, absolute mastery of the subject matter to your evaluator. Finally, we conclude. Conclusion: fraudulent transfers undermine creditor rights, and the law allows setting aside when made with dishonest intent. At the same time, it protects genuine transactions made in good faith. Never end an essay abruptly. A strong conclusion summarizing both the rule and the exception seals a perfect KSLU answer. Follow this architecture. Cite your exact sections and cases. Underline your key phrases, and you will absolutely dominate this exam paper. But before you go, ask yourselves this. As we move into a modern digital economy, how will Section 530 adapt to debtors hiding assets through cryptocurrency and international shell companies? Ponder how you would argue that in a modern courtroom. Class dismissed.